Good morning to all the viewers. Myself, Dr. Rajesh Singh, Associate Professor from Parul Institute of Law, Parul University. Warm welcome our eminent speaker for the today's topic on the application of the forensic principle of forensic science laws. And today's our uh, guest is Dr. Namita Singh Malik, who is the Dean and Professor from Galgotia University, Gautam Buddha Nagar, Uttar Pradesh. Uh, a warm welcome to you, ma'am. Now I will just introduce about ma'am profile. So basically, madam is a dean and director and dean at the dean and professor from Galgotia's University. She is having a wide experience of 14 years of professional experience in the legal field. Initially, she has 3 years in the court practice and 11 years in the academics. She has a she has processed a rich experience pertaining to the academics and administration related work. She has an ability to deal with the students coming from the various nation, region, social and cultural backgrounds. She has taught across the various streams and spheres of the knowledge distribution at the doctorate, postgraduate, and undergraduate level. So she has delivered the lectures to the groups of the student using the basic and advanced teaching techniques to inspire and motivate them for the higher level qualification and then employment. She represents the law school in the key committee at the university level. She is awarded twice by the university for the performance of academics and administrative work. She has been awarded with the Academic Excellence Award 2020 and 2021 in the 4th National Symposium Award ceremony organized by the Droit Panel Groups in collaboration with the University of Allahabad on 10th January 2021. As per the legal council, she is also the for the legal council for the awareness state sector. She participated on the Women's Indian Chamber of Commerce and Industry, member of the Global Alliance for the Justice Education, and International Community for the Clinical Legal Education. She possesses a good leadership and administrative skill, organized around 100 events of curricular and co-curricular and extracurricular nature, such as the National Mood Competition, National Conference, and Seminar, faculty development programs, workshops, panel discussion, interactive session, and other curricular and extracurricular activity. She has delivered lectures, talks, speakers, and adjudging the mood courts in the various colleges. She has participated in 15 faculty development programs and workshops and successfully completed the 9 MOOCs from the international university like the Harvard University, Oxford University, University of Pennsylvania, Stanford University, University of Hong Kong, University of Geneva, and Western University, etc. So on this platform, I warm welcome Dr. Namita Singh ma'am, and I will tell our professor, Mr. P.N. Parikh sir, who is the very senior professor, as our dean sir has some difficulty today, is unable to join. So I request Mr. P.N. Parikh sir to warm welcome our eminent speaker, Dr. Namita Singh Malik madam. Over to you, sir.
Yes, good morning to you. I, on behalf of Dr. Akhil Syed, who is on leave due to some domestic reasons, I, on behalf of Parul Institute of Law and Faculty of Law, welcome Namita Singh for today's webinar, who has got wide experience in the field. I also thankful to her for accepting our invitation and sparing her valuable time for us. I wish all success for this webinar. Over to you. Thank you.
Thank you so much, sir. Thank you, sir, and thank you, Dr. Rajesh, and thank you to the entire Parul University to for giving me this opportunity. I'll try to do my best in whatever limited time it is there. So, a very good morning to one and all the participants and the faculty and all those who are there in the session today. I would be speaking today about the forensic science and law interface.
And this is the snapshot of what is there before you so that the participants also know that what we are going to discuss today. So the contents of the lecture are there before you on the screen so that you have an idea. Okay. Moving forward, I hope I'm audible. It is all going fine.
Yes, ma'am. Yes, ma'am. Yes,
Audible?
ma'am.
Yes.
Yes, ma'am.
Okay. Thank you.
Yes, you are audible.
Well, Justice Hall has said, I quote, The object of criminal law is in terms of order, survival, security, maintenance of conditions which permit the society to progress, experience of higher values, and finally the good life which subsumes all the ideals of the world in which a democratic society lives. Now, any society, we know every society, every nation has so many laws, but for every law and for every country, for every nation, whether it is a developed nation, developing nation, or an underdeveloped nation, the maintenance of law and order and the way the criminal justice system administers and provides rights and justice to the people is something which is very, very important for all the countries. Now, there has been a time earlier when the traditional methods of evidence seeking, proof, looking for evidences were there. But as in time and the way the society has moved, the technology has developed, we are no more dependent upon the traditional methods and not totally dependent upon seeking, running after witnesses and testimony. We have scientific methods, techniques, and technology which can help us in coming to the very fair trial. Any issue related to justice, criminal law, it begins with the very first thing, that is the investigation. Investigation is the first step towards providing justice in case of any criminal matter, specifically if I talk about. So when we talk about investigation, forensic science plays a great role. So let's have a look at what exactly it is and how it further works. Now, this term forensis is something which is derived from the Latin word forensis, which means related to courts of law and all the things which are there, debates in public related to laws, discussions and debates related to laws, and anything which is there presented in court of law. In a very simpler term, if you try to understand, then forensic science is a branch of science that deals with the application of scientific methods and techniques to matters under investigation by court of law. Now, we know that in any investigation, any matter which is in court of law, when we apply scientific methods and techniques, we call as that this is the application, this is the forensic science, that role comes into play. So the application of all this, that works. Now, what exactly is forensic science? Forensic science is that branch of science which draws and which is based upon other basic sciences. Now, what are the basic sciences? The basic sciences are physics, chemistry, biology, and the subdivisions of physics, chemistry, and biology. For example, one division of, we will come to the other subdivisions. One of the division of chemistry is toxicology. One other division of biology is botany, and all those subjects. So, forensic science, it draws upon the very basic sciences, physics, chemistry, biology, and their subdivisions to recognize, identify, and evaluate physical evidences which are presented in any case, in any kind of an investigation. Now, if we look at how the forensic science has developed, then forensic science it's not something which is very new. It developed, and it is something whose historical traces can be dated back to the Egyptian civilization back in 3000 BC, and also to German and Roman societies. The first book, Zi Wen Ji Lu, which is also called as The Washing Away of Wrongs, was the first Chinese book written by Song Ci in 1247 on forensic sciences. And this book was so much appreciated that this book has carried over the debates, and the entire thing got translated into many other languages as well. In German, in French, in Japanese, in Chinese, in many other languages, the interpretation, the analysis of the book was translated. Then this book explained how to distinguish an accidental death from a murder by examining the weapon used to cause death. Apart from that, this book is something which is being read by most of the forensic experts and scientists, because although it has been written long back, but at that point of time also, the very basic questions of forensics were answered in that book. Like, for example, how to preserve evidences during the examination process. Now, how do we preserve evidences during the examination process? We preserve evidences through chemicals, or we might preserve evidences in case of any digital investigation on the digital media, on the digital platform. Then how to make an antiseptic, how to extract a hidden injury from dead bodies and bones, how you can, all these questions were asked, they were all were answered in this book. So how to calculate the time of death based on the weather and insects. Now this is a question which includes the understanding of biology and also the understanding of the impact of weather on people, on insect, that how things degrade, because of that. So all these questions were answered in this particular book. Now, before I come straight away to the various techniques and technologies which are used, let's quickly have a look at few important timelines in the forensic field. Now, what I felt was very important, I have tried to mark them in the red color. 3500 BC, it was the Mesopotamians performed animal autopsies in order to communicate with divine forces. Now you see this, because that time somehow people were worshipping animals. So even if you are doing an autopsy on animals, or you are anyway, connecting, doing something with the animals, you are anyway trying to get in touch with the divine forces. So maybe that was the reason doing that. But yes, that means we have begun with the autopsies on animals first. This is one take I want everybody to have from this. Then in 1247, this book was written, The Washing Away of Wrong, the first forensic text. Then moving further, moving further, 1868, which I found was again very important. Friedrich Miescher, a Swiss biochemist, discovers DNA. Now you see, when DNA was discovered, almost more than 150-170 years. 1868, first time the DNA was discovered by Friedrich Miescher. Then 1876, Cesar Lombroso. We all know who Cesar Lombroso. He has published The Criminal Men, which states that criminals can be identified and classified by their physical characteristics. Cesar Lombroso, the positivist school, who has given certain kind of, characteristics, 15, 16 characteristics, on the basis of which you can identify whether a person is a born criminal or a made criminal. So that interpretation has come up in 1876. Then moving further, few more which I got, Then 1892, Sir Francis Galton, he has published his classical textbook Fingerprints. So how fingerprints are important in, and how they can play a very crucial role in identifying a perpetrator in any investigation, in any criminal trial. The credit goes to Francis Galton, 1892. Then 1893, Hans Grover, who has published Criminal Investigation and coined the term criminalistics. Criminalistics is one term where you can, is one method where you can analyze crime and the crime related and the entire profiling of victim, criminal with respect to the crime can be done within this branch. So that was something which has initially taken place in 1893. Then moving further, the human 1901, the human blood grouping was discovered by Karl Landsteiner and adopted for and was used for various purposes. Now we understand that today we know that there is various kind of blood groups. So that was something which was being introduced first by Landsteiner. Then 1903, the first systematic use of fingerprints for criminal identification in the United States began in New York State prison system. So that way, and then in 1930, lie detection began. Lie detection, which is also called as the polygraph test, that all begin in 1930. So almost we are 90 years that we are doing this lie detection test. How it is being done, we'll come to that quickly. So I'm moving further. I just wanted to show very quickly the timelines. The participants can have they can have access to this presentation if they're finding it that it is relevant for them, and they can even have the snapshots just before you to go through that. Then DNA fingerprinting techniques was developed by Sir Alec Jeffreys in 1984. Then moving further, So these are the very major timelines which are there in the forensic area. Now let's have a look at few people who have really contributed to the branch of forensic science. Matthew Orfila, a Spanish scientist. He belonged to the discipline of chemistry and toxicology, and he is called as a founder of the science of toxicology. Toxicology is the branch, it is a subdivision of chemistry which deals with toxins, how toxins and drugs and toxic. So he's called as a father of toxicology. You can get the other details through this reference is also there in the slide. Then Francis Galton. Francis was a British scientist. Anthropology, sociology and psychology was his discipline. He is famous for his studies in human intelligence, also known for coining the phrase nature versus nurture. Can you nurture a leader, or leaders are naturally born? Can you nurture a person in the right way, or are the criminals born, are they nurtured in that way? So all that discussion that goes along with the reformatory school of criminology, that reformatory school of crime and sociology, that can also be linked to this concept. So this was another person. Then Hans Gross, an Austrian criminal jurist and criminologist. He was the founding father of criminal profiling. How we do criminal profiling, which kind of a criminal is more tempted towards doing a particular kind of a crime, how you can relate to that. Every criminal does not commit same kind of a crime, they do as per their instincts, their frustration, the instincts and all that. So that all is done through criminal profiling. Then in 1893, his book Criminal Investigation, a practical textbook, was published, and he started the first forensic journal titled Criminology. This was the first forensic journal which was started by Hans Gross. Then if you move further, there's another one person, Alphonse Bertillon. He was a French police officer and a criminologist. He belonged to the field of criminology, anthropometry, and he devised the first system of person ID using a series of body measurements. And he's famous for designing crime scene kit, which is still used in investigation. So his major contribution is designing the crime scene kit. So this is another one important person. Then Albert Osborne, Osborne. Albert Osborne was again an American scientist. He has been very instrumental in bringing the first American prominent in the field of question documents and forgery detection, and author of several books. So he's one person, yes, again, who's very important in forensics. And then Karl Landsteiner, who was an Austrian biologist, physician, and immunologist. He belonged to the field of biology and physics, and in 1901, he discovered that human bloods could be grouped into different categories, A, B, and O. We know these are the 4 categories. So the entire credit goes to Karl Landsteiner for that. And yes, in 1930, he won a Nobel Prize for his contribution to science. And further, in 1940, he has also developed the Rh factor in blood. Moving further, Leon Lattis, a professor and a scientist at the Institute of Forensic Medicine at the University of Turin in Italy. He belonged to he has further done more research on the blood groups A, B, and O. So further, through how you can get the exact blood group of people by extracting them from dried blood stain. This was his main contribution. So he was there. And then Edmund Locard, he formulated the basic principle of forensic science that every contact leaves a trace. Now we will come to it when we will come to the basic principles of forensic science and their application in law. Edmund Locard, where he talked about that whatever you do, wherever you get in contact, it is going to leave a trace. If you enter a room and you move out, and if you have taken a bath and you had a perfume, you have put up a good perfume, the moment you will leave, the room will still, will have a good fragrance. And it could be vice versa also. So that way it could work. Okay, moving further, Calvin Goddard. Now, Calvin Goddard is credited with the fact that he has contributed in the field of forensic ballistics. Ballistics is the study of weapons, bullets, firearms. So Dr. Calvin was a colonel, and this is what was his major contribution to the branch of forensics ballistics. Then Edgar Hoover. Edgar Hoover was director of the FBI from 1924 to 1972, and he has established a fingerprint file, and he has also done a lot of work on crime detection laboratory. He founded FBI National Academy, and he served a lot in FBI for many, many years. Okay, now let's come to this thing. This is important, and that is what are the various branches of forensic science, because before you understand or before you move up to how it interjects with law or how it interplays with law, let's have a quick look at the branches of forensic science. These are the branches, moving first with forensic biology, physics, chemistry. Now the upper three branches are the basic sciences, very, very pure basic sciences, which everyone must have studied till 10th standard: biology, physics and chemistry. Then toxicology, dentistry, which is also called as forensic odontology, psychology, ballistics and cyber forensics. These are the major branches of forensic science. So I would like to speak here. I would request yes, we can keep the screen more. We'll discuss a little more. Now, what does forensic biology talks about? See, forensic biology, it deals with the examination of the evidences pertaining to living beings and their associated biological materials commonly found at the scene of a crime. For example, suppose if a crime incident has taken place, somebody has been shot. Now, what could be there on the crime scene if somebody has been shot? You might see blood, urine. In case of sexual assault, semen, sweat, saliva. There could be some other kind of thing. There could be some kind of animal and human, some kind of traces over there. So, forensic biology actually looks into and analyzes these kind of the data which is used for further investigation. Similarly, examination and identification of materials like wood, hair, fiber, facial matters, nails, bones, teeth, leaves, seed and other plant materials, that also is analyzed under forensic biology. Then further, this branch also deals with the determining the paternity and maternity. So the DNA profiling, determining the age and sex of the human beings, maybe the victim or the accused, the skeletal remains, how through skeletal remains you could make it out when a person must have died. If a person has been killed and actually, been killed and thrown somewhere, so in what time, how the body will decompose. So all that study is there, which is being done by the people who are the forensic biologists. Now, one more thing, I hope the students here, I'm sure must be knowing, but in case if they don't know, all forensic scientists do not have expertise in all the branches. Everyone is working in a different, everyone is expert in a different way. Forensic biologist can only give and is only competent enough to testify something which is relating to his field. He cannot testify for something which is related to forensic ballistics. So that is why we have to see that, okay, they all have different expertise. Now, forensic physics, what is that? We know that whatever data you get from a crime scene, now why I'm saying data, hair is a data, blood is a data, urine is a data, all the data, whatever you gather from a crime scene, that all can be seen, analyzed through certain machines, microscope, spectrometer, other optical devices and all that. So forensic physics indirectly plays a role in analyzing any kind of a data for the purpose of forensics. They do not have very direct role, but yes, we have the machines and all that. Through that, it plays a role. Now, forensic chemistry. We all know all the data which you are going to collect from a crime scene, how you are going to analyze it, how you're going to preserve it. That all we do through the very basic, this branch of forensic chemistry, preservation of data, and then further analysis through the use of various chemicals that is being done through this branch. And then forensic toxicology, pathology, again, toxicology wherever drugs are involved, if a person has died. For example, suppose I'll just give you a very simple example. Suppose if somebody has given me a poison and I die because of that. Now, what kind of a poison has been given to you and how you respond to that For example, if you give me something which doesn't have a sour taste, which doesn't have a bad taste, and I eat it in general, that means there could be a possibility that it was and on my dead body there are no marks of any kind of a stress or any kind of resistance in the area, in the place, at the place where my dead body is being found. In that case, and if the report shows that I was given a poison and there are no struggles, chains of struggle being found, then you can analyze, you can do one interpretation that may be that the kind of poison which has been given to me was something which was not a rough poison, which was a tasteless poison, or you can say which was a poison which was maybe mixed in something and was given to me, because I might not have resisted to that, because every poison, again, it shows different kind of it reacts to body in a different manner. So that all is the branch of forensic toxicology which it deals with. Then forensic odontology and dentistry. Now this branch plays a very important role, especially in case of mass fatalities, where people die in a big accident, 100 people, 50 people dying and meeting in a terrorist attack or something. How you will identify people? That is through this branch of forensic odontology, because it works on the very basic principle that no two people can have exactly the same dental imprint. Similarly, no two people can have the same finger imprints. So that is how these, they are based upon. Then forensic psychology. Now, forensic psychology plays a great role in criminal investigations also, especially when we talk about the branch of brain, the techniques of brain mapping and the technique of polygraphy test, that is lie detector test, that all comes within the branch of forensic psychology. Forensic psychology, where through various measures you're trying to see the psychology. So psychology, forensic psychology, DNA and all that comes within it. Then forensic ballistics, as I've said, that this is one branch which talks about weapon, use of weapon and firearms and how all that, so that goes with that. And then cyber forensics, digital forensics, how you save data and how any data, any crime, any data related to cyber crime, how it is being saved, how it can be analyzed, how it can be preserved. So that all goes into cyber forensics. Now moving on further, let's go, request for next slide please. Moving on further, there are these are the fundamentals, 7 fundamental rules of forensic evidence. Let's look at the fundamental rules of forensic evidence and then let's see how it is related to law. The first principle is the law of individuality. Then principle of exchange, law of progressive change, law of analysis, law of comparison, probability and circumstantial facts. The first one, the principle of individuality. The principle of individuality, the very first take from this principle is that every object, whether it is natural or whether it is man-made, it has an individuality which cannot be duplicated in any other object. For example, human beings, every human being, every species has a particular, they all have different, we all have an individuality in terms of looks, in terms of composition, in terms of bodily composition, in terms of appearance and everything. Secondly, everything in this universe is unique. Species have unique features, unique bodies, unique appearances and everything. And nature's unique creation manifested in biodiversity is much appreciated. We know that we have so many kind of species. Then further, it is based on the principle that neither nature has repeated itself, nor can a man repeat his action with exact accuracy. Something unique shall be attached to the retake of a man's action. For example, today I am delivering this lecture. If you ask me tomorrow also, okay madam, you deliver the lecture, I will not be repeating it, howsoever best I might try. So this is what it says, that you cannot repeat your action with accuracy. So these are the few principles, very basic principles of first very principle of individuality. Now let's see how this principle is applicable to crime and to law. See this principle, for example, you take sand in one hand and you take salt in one hand, sand and salt, if you put both the things in two different bowls, they might appear a little bit similar, little bit similar. But when you will like we said that bura and namak, हम लोग घर में जब खाना बनाते हैं bura और नमक दूर से देखने में it might look very the same thing, but when you touch it, even if you're going to use any of your sense, touching or even your tongue या touch skin, दोनों में से किसी एक को छूते समझ में आ जाता है ये बुरा है या नमक है. Why? Because through the help of your 5 senses, your eyes, your ears, your smell, taste and skin, you can make out the difference. So everything, every object has an individuality. Now, how we apply this principle of individuality to law? We can apply in the sense that every individual and every stakeholder who's involved in a crime scene, those who are the direct people involved in a crime scene, victim, perpetrator and witnesses, they have their own individual characteristics. And if you are able to identify, pinpoint and zeroed upon, if you can figure out the individual characteristics of a victim or a criminal, you can lead to and you can find out who the culprit was. So every victim has an individuality. That is how people, the way a person commits a crime, the way they do it, you can track it. You can track it through that way. So this is one principle. Now the second principle is principle of exchange. Now principle of exchange state that when 2 or more variables, either they are living or non-living, whenever they will come in contact with each other, there is an exchange of physical, chemical properties among those variables. We can change the slide. Next please. Principle of exchange, next please. Next and next one more. Next one. Thank you. This principle was first enunciated by the French scientist Edmond Locard and is also called as Edmond Locard's maxim on interchange, that it is impossible for a criminal to act, especially considering the intensity of a crime, without leaving traces of his presence. That means आप कहीं भी जाएं, आप अपने निशान छोड़ते चले जाएंगे. क्रिमिनल भी कहीं ना कहीं अपने निशान जो है वो छोड़ जाएगा. अभी कैसे छूटेगा? How you will do that? For example, there could be certain things which can be very clearly visible. For example, even if you give somebody a mark, footsteps, fingerprints, that is one very simple thing which you can find. In addition to that, when an object like a knife gets into the touch of a body, the way you use that knife into the body will also tell exactly what kind of an injury it can give. That can be very easily marked. आप किसी बॉडी को देखिए जिसके ऊपर बहुत सारी इंजरी है और आप उसके मार्क्स को देखकर ये पहचान सकते हैं whether the injury was given by a knife or it was given by a bullet or whether it was given by a gaseous object or whether it was given by a liquid object. अगर जलाया गया है तो the body will have a foul smell. It will have a foul smell. It will, be demolished in a different way. It will be impacted in a different way. But suppose if it is a gaseous, through the use of gases, somebody has been killed, then the difference is the reactions would be different in the crime scene itself. So similarly, in case of bullets, the wound and everything. So whenever 2 objects will intersect, they will come in exchange with each other, whether they are one object, man-made or natural, or man-made artificial, or man and artificial object, anything, they will leave certain traces. So this is what principle of exchange says. Now principle of progressive change. Now law of progressive change is that with course of time everything changes. सब कुछ बदल जाता है time के साथ, because time के साथ we all grow old, है ना? So this principle applies to everything, living and non-living things. Furniture भी पुराना हो जाता है after 5 years, 7 years. हम भी change बदल गए हैं इतने सालों में. So natural forces, when they operate with time, they lead certain things, certain marks on living and non-living objects. Now with passage of time, body is also changing. With passage of time, if we are not able to trace people on time, there might be a situation that it is difficult to identify the culprit few years ago. एक ये इस तरीके से इसको भी आप रिलेट कर सकते हैं with respect to crime and law, that if the culprits are not being taken or not being arrested, or if it has not worked well in time, then there is a possibility that you might not be able to identify them because of the principle of progressive change. हाँ, एक अलग बात है कि today we have that app, I don't know, that face app which will tell आप 10 साल बाद कैसे लगेंगे, 15 साल बाद कैसे लगेंगे, वो एक अलग चीज है. But yes, with the progressive change, it is difficult to identify not only the criminal, maybe even the scene of occurrence. अगर जहां आज suppose if today something has happened in the morning. Now, if the investigative teams goes after 3 days, the crime scene, maybe after 3 hours, if there is a late investigation, the entire crime scene and the place will not give any such credible data for the purpose of investigation. Because हो सकता है बारिश हो जाए, हो सकता है आंधी आ जाए, कुछ भी हो जाए. So it is very important कि considering the principles of progressive change, as early as possible, a person, a team's experts come to know that something has happened, they must visit the crime scene as early as possible to gather the right kind of evidences. So this is how I relate this progressive change to the law. Then moving further, principle of analysis. Now, principle of analysis states that analysis can be no better than the sample analyzed. अगर आपने sample जो analyze किया है, if that sample itself is not well preserved, if it is not well preserved, it will not give the required results. Because in that case, if it is distorted in that way. So this principle emphasizes the necessity of correct sampling and packaging for effective use by experts so that they can draw a scientific comparison and analysis. So this is how it is important. Now, okay, if we really see that what really happens, then we know that because of the fact that that forensic science to a great extent is not in India at least. It is something which is a new field, which is a novice field. Since last maybe 20-25 years, more people are knowing. But still, if you see at the ground reality, maybe the policemen, maybe the normal police wala and the people, those who are there, they are not much trained in that. And many times because we have shortage of forensic experts in the country, the trained experts, and maybe the resources also, because we do not have many of the institutions also to teach. At that time, many of the time, the sample which is being picked, it is not picked in the right manner, and it gets distorted. अगर late है, sample ठीक से नहीं preserve हुआ है, so it might not give the right result. Now, इसमें एक चीज भी important है. Likes can only be compared. You cannot. This is the next principle of comparison, which says that you can only do comparison between two things which are alike, which are likes. You cannot compare two different kind of things altogether. उनको आप compare करके आपको कुछ नहीं मिलेगा. So that means whenever you are comparing two data for the purpose of forensic investigation, make sure they fall into the same category. For example, किसी का murder होता है, right? And you see that okay, the girl who is being murdered, hair है, human hair है. Now you cannot compare human hair with an animal hair. Right? You cannot compare, the other things also, the semen also, the blood also with the animal. So वो आप नहीं कर सकते. Because you have to compare. The likes can only be compared with the like things. You cannot compare it with something with which it doesn't go. So the comparison has to be made. Similarly, for example, if you get an information as a forensic expert, or I'm just giving you a hypothetical situation that somebody has drove in an area on a sand, बड़ी सी गाड़ी आप लेकर चले गए और वहां पर वो मार्क्स है. अब दोबारा से आपको अगर you have any doubt and if you have caught up a suspect, then if you wanted to compare and if that another suspect has a different car, you cannot say कि भाई यही वही गाड़ी यूज हुई थी, because वो टायर मार्क्स भी मैच होने चाहिए. आप बुलेट की गाड़ी के अगर आप मोटरसाइकिल के अगर आप मार्क्स कंपेयर करें तो वो मोटरसाइकिल से ही कंपेयर, गाड़ी से नहीं कंपेयर करेंगे, है ना. So this is what actually it is trying to say, that the tire marks can be compared to the tires only with the same kind of vehicles, hair sample, everything that has to be compared. Similarly, with respect to handwriting also. For example, the way my handwriting comes on paper, it will be different as compared to my handwriting on wood or my handwriting on some other metal. So even a person's handwriting will differ on wood, on metal and on paper. So आपको अगर if you want to compare my handwriting, you can compare my handwriting from one page to the other. अगर आप उसको wood से compare करते हैं, my handwriting on wood or a metal, it will not suffice. It can easily be questioned in court कि मिलोड ये नहीं हो सकता, because it is against the principle of comparison of forensic science and investigation, right? So this is what I wanted to say. Okay, principle of probability. Now the principle of probability says that all the identifications, definite or indefinite, are made consciously or unconsciously on the basis of probability. Probability, mathematical concept है. Probability का concept is there in law also, where it is there in the plea of alibi. Whether what is the probability of a person being able to present at the same time at two different places. plea of alibi, जहाँ हम कहते हैं नहीं ये नहीं हो सकता, अगर मैं बॉम्बे में हूँ तो मैं कहीं और कुछ और क्राइम किया है ना. तो principle of probability is there, which is there recognized in our section 11 of Indian Evidence Act as well. So these are these are the 7 principles which can be understood, which can be compared, which can be understood for the purpose of any kind of investigation. Now let's come to, okay, let's move further, that why knowledge of forensic science. Okay, there's one more, principle of circumstantial evidence. Now, if you see the principle of circumstantial evidence, it is based upon the proposition that men can lie, but facts do not lie. That means the circumstances speaks for themselves. True belief only becomes knowledge when backed by some kind of investigation and evidence. So, जब हम circumstantial evidences देखते हैं, when you try to see things in totality, you know, then only right, you might get great leads through circumstantial evidences. And we know that in evidences, the way you cannot make a person guilty on the basis of any single evidence. You have to make sure that the entire chain of circumstantial evidence is complete against him. Then only you can make a person guilty. आपने कह दिया ठीक है, not even in case of forensic investigations also, just because in a DNA analysis or in a narco analysis or in any kind of a polygraph test, अगर हम बोले lie detector test किसी ने बोला, you can't make a person guilty because of that. आपको सब देखना पड़ेगा, सब match हो रहा है कि नहीं, पूरा join, whether the dots are joining or not. So that is the one thing, that the chain of circumstantial evidence has to be completed for that. So this is important in law. Now moving further, why knowledge of forensic science is important for lawyers and law students. Now it is important for lawyers and law students because it is used extensively to solve cases that falls under criminal laws nowadays. Apart from that, it is also used to solve civil law cases also. DNA के basis पर civil law के भी लोग बहुत claims कर चुके हैं. We know ND Tiwari वाला case, right? Then forensic science can be very effective in proving the existence of a crime. It helps in acts such as identification of perpetrator, establishing a connection to a crime through an examination of physical evidences, administration of tests, interpretation of data, clear and concise reporting, and by truthful testimony of a forensic scientist. Forensic scientist में again ये ध्यान रखना है कि अगर odontology का question है तो हम biology के expert को नहीं बुलाएंगे, नहीं तो फिर वो जवाब ठीक नहीं मिलेगा. Now let's quickly come to the major analysis of major forensic techniques, and today I would just be discussing these 3 major: narco analysis test, polygraphy test, and brain mapping. Let's start with the first one, narco analysis test. Now, if you see this first one, narco analysis test, it is a kind of a psychotherapy which is conducted on a person by bringing that individual into semi-sleep state. Narco analysis में करते क्या है कि you give some drugs to a person. Now, when you give that drugs to the person, you cannot give a drug to the person if the person has not agreed to that. So, आप एक state में लेकर आते हो where you use, there are the 2 kind of drugs usually जो use होती हैं. I'll give the name also. Okay, so you make a person get into a kind of a self-consciousness state से आप लेकर आते हो, and then when a person is under some kind of a drug, some kind of a chemical reactions takes place in the mind and the body, that the person is more susceptible to give some kind of the evidences which are required for the purpose of investigation. Now there are 2 most common drugs used to bring into play the narco analysis test, and these are sodium amytal, which is also known as ambobartial or amlobartian, and sodium pentothal, commonly known as thiopental or thiopenitone, is used by psychiatrists on the subject. So ये 2 तरह की drugs हैं जो use होती हैं. Now होता क्या है इसको use करने के बाद? When you give these kind of drugs to the people, its effect is that it makes the subject relaxed and she becomes susceptible to suggestion. The subject becomes communicative and can easily tell the truth क्योंकि अब उससे बोलना शुरू कर दिया है. Now again, now the question is how much of the drug, how much of the dose is to be given. Now the dosage of drugs, it depends upon the suspect's age, sex, health, physical and mental condition. उसके अलावा apart from that, normally 3 grams of any truth serum is dissolved in 3000 ml of distilled water and then it is injected to the subject intravenously, मतलब रुक रुक के बीच में उसको दिया जाता है. By this subject's imagination is neutralized, उसकी imagination power खत्म हो जाती है and he is not in a position to manipulate things but can only answer specific simple questions. This is how narco-analysis test it actually works. Acha, few more things. What is when you give this kind of when you do this test, there are certain things which are further need to be important here, like this test has to be recorded, video recording. If not video apart from video recording, tape recording. Then you are using distilled water, disposable syringes and prescribed truth. जो आपको drug आप दे रहे हैं, उसका clear information होना चाहिए, आप कितना दे रहे हैं. And also, when this narco-analysis test is being done, there is compulsory that physician has to be there, neurologist has to be there, cardiologist has to be there, then anesthetist and a lawyer. And without the permission of the person, narco analysis test usually it is not conducted. हाँ, exceptional cases में हो सकता है. Exceptional cases में हो सकता है. For example, in case of a terrorist attack, in case of serious crimes against the nation, वहाँ पर permitted है. Otherwise, if a person does not agree to that, you cannot do that, right? So these are the presence of authorities are important. Precautions हैं. The lot many precautions has to be conducted. Like the narco analysis test has to be conducted in a well lit room, which is otherwise quiet. Then prior consent of the subject is important. Then this consent should be recorded and it should be done before a judicial magistrate. The judicial magistrate is also important. Then the physical and emotional implication along with the legal implications of the test should be explained to the subject by the lawyer. कि देखो जो ये कर रहे हो इसके ये impact होते हैं. And yes, also the person has to be told that it will not amount to a confessional statement. Rather, it will only be a statement to the police. So this also has to be told to the person who is the subject of investigation. Then the drug is to be diluted and all that. Then ये भी देखना होता है caffeine तो नहीं दिया पहले, ऐसा तो नहीं चाय कॉफी पी के, तो वो भी देखना होता है. Because then interview, जब आप intervening drugs देने के बाद जब आप interview लेते हैं उसमें भी the time should not exceed. You cannot interview a person for more than 1 hour. So बीच में you have to take few breaks also. And also further the guidelines which are given by NHRC, they have to be followed for the purpose of narco analysis test, and then only it can be given. And then फिर वो चीजें अलग हैं that you should not, the person who's subject to the test should not have taken eaten something for 5-6 hours, वो सब भी होना चाहिए. And then presence of authorities, that is there. So those things are there in case of these things. So this is majorly about the narco analysis test. Now, अब इसमें question है कि what is the extent or what is the result of this test? Is the test of the result 100% accurate? Then the answer is no. The test is not 100% accurate. These are the limitations, that if the subject has been a drug addict or alcoholic, then in that case the person might develop some kind of a tolerance level. थोड़ा सा tolerance level बढ़ जाता है. And वो semi consciousness state में इतना easily नहीं आएगा. The person can tell lie. So that these are few limitations which are there in case of narco analysis test. Now let's move on to the next one. अच्छा कुछ इसमें भी है. If what is the time now? It is 12:20. Okay, I'll check. Okay. I have to wind up at 12:30. Dr. Rajesh.
No, madam, you can take more 5 to 10 minutes. You can
5 minutes ऊपर ले लूँ. अच्छा ठीक है. Okay. ठीक है. Okay. Thank you. Okay. Now when this narco analysis test is done, when you ask the questions, आप पहले general questions पूछते हैं. Again, I'm giving you a little more of detail of that. And then when you see that the person's tongue is now slurring, slur होना शुरू हो गया, then you come to the real questions. Then initially you start by questioning and asking the pleasant memories. Negative questions नहीं पूछते हैं आप पहले initially. And then धीरे धीरे you come to what exactly you wanted to take from that person. So this is how we do in the narco analysis. Moving further to polygraphy test. The polygraph test, which is also called as the lie detector test, is another scientific tool which works on the principle that body activity changes during changes due to emotional factors. These changes are involuntary and automatic. Now, polygraph diagnoses the lying in response to occasion that produce physiological changes which are different from that those arise in the normal response. For the purpose of polygraph measurements, changes in the area of respiratory system, cardiovascular system, and electrodermal system is being observed. This is also called as polygraphy test को हम lie detector test भी बोलते हैं, and it works, it is being conducted in 3 phases: pre-test interview, polygraph examination, and post-test interview. These are the 3 stages of this polygraphy test. अब ये होता कैसे है? In this particular test, it is, you attach certain instruments to a person's body to measure certain things. For example, blood pressure, pulse rate, respiratory system, skin conductivity, and through that you see how a person is emotionally responding to that. Through that आप ये देखते हैं. आपने देखा होगा एक प्रोग्राम आया था सच का सामना टीवी पर, बड़े लोग आए थे उसमें.
Yes,
तो
ma'am.
ये I think that was the time when I saw it, that how it works. Then so there are 3 stages through this test is being conducted. Now in the first stage, that is the pre-test interview, the first stage में you introduce yourself to the subject. The subject को बताना पड़ता है again that okay, this is the procedure you are going about and these are your rights. This is in case of all kind of analysis, that you have to tell the subject that okay, whatever you are saying here, it will not be used against you, it will not be against you. वो self incrimination में नहीं fall करेगा. This has to be told, right? So this has to be told. And then in second stage you ask more deeper questions. And then, but yes, there are again few guidelines on that no questions which is related to political affiliations, religious and social beliefs, sexual preferences, ये नहीं पूछना है until unless that particular question is there, particular issue is there for the purpose of investigation. आप किस political party को support करते हैं ये नहीं पूछेंगे आप. आपका sexual preferences क्या हैं वो आप नहीं पूछेंगे until unless that is there in the question itself. Now okay, this through the second stage, when the real questions takes place, different gadgets are attached to the body of the subject for measuring the changes in the physiological conditions. जैसे rubber tube is fested around the chest for measuring the respiratory changes. Similarly, an upper arm, an inflated cut is wrapped for measuring the changes in the blood pressure and the pulse rate. कितना आपका वो पूरा जो है वो पूरा different हो रहा है. And so that all is being measured, and then you ask questions in yes or no. आपको ऐसा लगता है yes, no, and then you get the results, and then finally is the post session जहाँ पर you finally confirm to that okay what you have asked. Okay, then if you analyze the polygraph test, then if you look again into how successful it is and what are the limitations, then again this test does not tell as to whether the subject is lying or not. ये नहीं बताता है. What it just tells is that during particular questions, how your body, your respiration, your everything is moving. Pulse rate कैसे कितना ऊपर नीचे हो रहा है. In asking this question, no science is involved, and it wholly depends upon trickery of the expertise of the examiner. अब आपसे सवाल पूछने वाला कितना ट्रिकी है, आपसे हो सकता है वो बहुत सारा आसान सवाल आपसे बहुत कॉम्प्लिकेट करके पूछते हैं. यही है वो आदमी, हम देखते हैं ना, आप अपने ही घर के लोगों को क्वेश्चन करना शुरू कर देते हैं. You must have seen during those comedy programs of so it is how skilled you are in asking the question, right? So a person who can control his emotions to a great extent can still tell a lie if a person has control on himself by practice of yoga or otherwise. In this case the test is bound to fail. So आपका कितना वो practice है उस केस में it will not work. लेकिन इसका negative impact देखिए. If there is a person who gets nervous even on simple question, कुछ लोग छोटे से सवाल पे भी घबरा जाते हैं, उस केस में ये हो सकता है कि even an innocent person, if that innocent person is being put to this polygraphy test, there is a possibility that that person might show more symptoms of nervousness, and उसका जो result आए उसमें बहुत variation आए, pulse rate बहुत बढ़ जाए, blood pressure बढ़ जाए. Now will you say that this person is guilty? No, you have to again see the entire circumstantial evidence has to be taken into consideration. Then only you can say that this person is guilty. So this has to be again kept into mind. Now moving on further, and this is the last one, that the brain mapping technology. Now this brain mapping technology is another again very valuable scientific tool which is also called as P3 or P300 test. इसलिए इसको ऐसे भी कहते हैं. Now, in this particular test, it is non-invasive. देखिए, non-invasive का मतलब it does nothing goes into your body that way. Brain mapping is non-invasive and it is a painless. Nothing is being attached. कुछ नहीं जाता है body में ना. It is something where a person brain reaction of brain to certain things, to certain sound, to certain visuals is being tested. It is being tested. Now, when you do this kind of a thing, in case of brain mapping, see, देखिए, brain mapping के अलावा there is one technique which is called as brain imaging. What kind of images brain shows? And now, for that purpose of brain imaging, through color Doppler, all the aspects of brain and areas of brain, they can be shown in different colors. And this brain mapping is used in general also for non-investigative purposes also. For example, what is the structure of a person's brain? कितना बड़ा दिमाग कितना बड़ा है, physical structure, brain में कौन सी चीज कहाँ है, which part is more active and all that all can also be seen through this brain imaging. Then identifying symptoms and the root causes of certain diseases, वो भी brain imaging के through होता है. Then developing targeted treatments. Doctors might see कि okay ठीक है, आपके brain imaging करिए तो ये पता चल रहा है कि इसको खाने से या इस situation में आपको trigger होता है headache, migraine trigger होता है. Then they can develop the further targeted treatments can be developed. And how does the brain communicates? कितनी जल्दी restore करता है, कितनी जल्दी react करता है? That all is done through this brain imaging thing. Now, अब इसको हम criminal में कैसे use करें investigation में? We are using it in the sense that the person who is under investigation in this brain mapping technique, you show certain things to a person. And when certain things are shown to you, if you have had any experience of those things in past, your brain will react in a different manner. And if you're seeing those things for the first time, your brain will react in a different manner. जो पुरानी हमारी experiential चीजें होती हैं, उसमें brain अलग तरीके से stimuli आता है या नहीं आता है. और अगर if you see something for the first time, your brain reacts in a different manner. So through that, you can definitely identify whether a person has heard this voice earlier, whether a person has been to this place earlier or not. अब इसमें आप ये नहीं कह सकते that a person is really guilty or not. For example, suppose if there is a crime scene, कोई भी crime scene है, हम मानते हैं वहाँ पर there is one person who has been a victim, there is one person who is the culprit there, and there is one person who is a witness. तीनों ने ही वो crime scene देखा है, तीनों ने ही crime scene, witness ने भी देखा है, भाई witness तो देखा ही है, और victim और culprit वहाँ पर थे ही थे. So वो जो brain mapping अगर technique दो के ऊपर अगर if all these three people are going to be analyzed, तीनों में positive आएगा, तीनों में देखेगा that yes, brain has such kind of a memory, वो memory है, but because brain में एक particular memory store हुई है, आप ये नहीं कह सकते that the person is guilty, क्योंकि वो witness ने जो देखा है उसने सिर्फ witness किया, but उसको भी memory में वो feed हुआ है. So brain mapping technique का सबसे बड़ा एक तो है that it is a violation of brain privacy. It is a violation of brain privacy. It does not say through this brain mapping technique you cannot say that a person is totally guilty. It is used only to see whether a person has knowledge of an incident, has a knowledge of a crime scene or an incident, or recognizes a sound or a face, या कुछ भी पहले से, या it is shown for the first time. That is the only thing which can be done through this brain mapping. That can be only be done. And yes, this may not work in case of people who are old people, because एक time के बाद you start losing your memory. So this brain mapping technique might not work in case of old people. Okay. Now, I'm summing up now. There are many cases in which these kind of forensic investigations have been conducted in past, and can also be conducted in future also, obviously, because it is nowadays, court is saying that instead of we follow adversarial system in India, that we wait, the judges wait, okay, this person will say, judge, the advocates, adversarial hai, dono ko sunenge, and then we'll do that. Inquisitorial nahi hai, judges do not interfere, but a time has come, a time that when even judges, they have shifted to that inquisitorial system of questioning as of now. In law, in many leading cases, these all technologies have been used. In Godhra incident cases, in Abdul Karim Telegi case, who was the prime accused in stamp paper scam, in Arun Bhatt kidnapping case of Gujarat, in Nithari serial killers of Nithari, Noida, Selvi Murugesan, sitting MLA of Tamil Nadu case, Mumbai Police Inspector Daya Nayak on Naxalite Malika case, Abu Salim, a suspect of Bombay blast case, actress Preeti Jain, and there are many more. We are using all these technologies quite a lot. But what is important is, I'm summing up that yes, forensic science, as it is a part of the modern day criminal justice system, but still in India it is still in very formative years. And why I'm saying this further, I don't know how much nowadays. Yes, universities are teaching it, but when I did my LLB in 2005, this subject was nowhere. ये पढ़ते ही सीखा है और उसी में कोशिश करते हैं कि आगे उसको बांट पाएं, तो वो जरूर है. एंड यस, forensic, it is an interdisciplinary science. It has multiple stakeholders. Lawyer, forensic scientists are involved, legal practitioners are involved. It is very important that everyone who is a stakeholder in any forensic investigation should be trained enough. चाहे वो पुलिस है, चाहे वो judges है, forensic experts है, lawyers हैं, they all should be trained enough. Then only the right kind of thing will come. So that's it. And then yes, we need more of workshops on this. We need more of learning on this, and slowly, gradually, I think everybody's understanding of forensic science will improve a little bit day by day. I'm trying to improve mine. I hope this session some people will have some takeaways from this session, and I'm good. In time, I finished it within time.
Ma'am,
Thank you, Dr. Rajesh.
It's really very fantastic, ma'am. You have, first of all, I'm very much thankful that a wonderful PPT you have made, and with a very progressive example with the case law. Generally, that seems that it is a good preparation from your side, number one. Number two, ma'am, we have 300 students and they have certain questions, because I cannot put every question, but few questions which I am going to put up to you, ma'am, which the student has sent to me. The first question,
please.
Their first question is, because they are on the live, because they are around about 350 students. So some student have sent me on my questions on my WhatsApp. Madam, the first question is from one of the student that though we have certain DNA test, various technology, but still the cases are very slow in the courts. So what is the reason behind that?
We cannot blame any particular branch or science or technology or any particular stakeholder for the delay in the cases. The delay comes from all sides, from courts also, because of lack of judges also, because of at times because of the system also, investigation from the side of investigation also, from the police side also, from the lawyer side also. So there are reasons, but I think shortage of judges is one big reason. I think this is one big reason. But yes, it is, and yes, nowadays it is delay mainly because of COVID also. That's another thing. But I think all the stakeholders, because from all stakeholders there is some delay, and when all that gets added up, there's a lot of delay. So I think that's the reason. And yes, when it comes to one thing I would like to quote here, that if the investigation takes place in the right manner, and if it is foolproof, done in the right manner, if it is not subject to any further questioning, maybe then in that case some delay period that will cut short. एक बार ठीक से हो जाए, then you will not question it. अभी judges खुद ही satisfied नहीं होते that okay, investigation ही ठीक से नहीं हुई है. So I think that could be the reason.
One more question from one of the students, that why the signature is varying from place to place. Say, for example, when we are signing on the table, the signature vary. When we are sitting in the ground, the signing varies. So how this is to be taken care while taking the evidences in the court, ma'am?
Okay, this is okay. देखिए, जरूरी नहीं हो सकता आपका signature vary ना करे. There is a possibility that your signature might not vary on a board, on a metal, or on a paper. But the principle of forensic science gives you that liberty. It gives you that that benefit of doubt, that if you are using the signature on different things, you can always question it. आप उसको हमेशा question कर सकते हैं, and you can say that this is not my signature. So because you know why? Because the flow will change. On paper, the ink, you are using a pen. Even if you are using two different pens, you might see थोड़ा variation आ जाता है. So because of the texture, I think the signature varies. That's the answer to that.
Yes, ma'am. True, ma'am. Madam, one of your student, his your student Disha Pandey. She has raised her hand. So Disha, now over to you. Yes,
Good
Disha.
afternoon, ma'am. A
Good
very good
afternoon. So,
afternoon.
good
It
afternoon.
is always a privilege to hear from you. And because like this is the first webinar I have been attending on forensic science, it was very interesting and informative. One thing which just struck my mind was while you were going through the slides that ma'am you had mentioned that there may be some what we can say tampering with the evidence, or maybe the evidences are collected late, or we do not have so good resources who may be tackling with them. So, keeping this statement in mind, ma'am, don't you think that the admissibility of evidences relating to forensic science in courts then do also have scope of error? Means the way we rely on them in the courts and the way they are admissible, because there is always a scope of error. So, don't you think that how far can we rely on these evidences when it comes to admissibility in the courts? Is my question.
Yes, Disha. The scope of error is there with respect to admissibility of any such forensic evidence, and it will remain till the time all the people who are there, they are not aware of, and they are not being trained in forensic. For example, suppose if I am one of the lawyer for a person, and if I am bringing a forensic expert, as I said, of forensic odontology, giving expert comment on an issue of forensic toxicology, I am doing a blunder. I am doing it for my vested interest because that is going to support my client. Now, it is very important that when such experts are being named and their names are being given to the court for these are the experts, the judges should know that, okay, there should be very, first of all, transparency, that the judges should know who's going to testify for that, whether the person is really the specialized forensic expert in that area or not. So if those things are being taken care, if the people who are there involved in the entire system, if they are being trained, I think the forensic evidences and all that, they will become more admissible. They will become more admissible.
So, ma'am, I guess it can always be a lawyer's defense, right? That forensic evidences, you cannot always rely completely on these evidences. It's a very good defense to take, I guess. Then, yes, sir. Thank you, ma'am. Thank you so much.
Thank you.
Madam, one last question, which is my question, ma'am. Ma'am, first of all, I have gone through various in the provision of CRPC, Indian Evidence Act, because I am teaching this particular subject also. Madam, I face that when the judgment is being delivered, when there is a conviction was being done, and still when the matter came before the High Court and the Supreme Court is going to rely on the evidences which is on the trial courts. And sometimes when they found that no, the investigation was not proper, then they again remit the case to the High Court, and High Court again remit to the Session Court. So, ma'am, in these cases, if the reports are wrong, so what are the remedy available in our law so that this should be corrected and further this re-examination, re-investigation should not be there? So, what you can give a just lesson to us so that our forensic science students should understand that yes, when they are in the practice, what things they have to be take care in their life when they are in the practice, ma'am.
Okay. Okay. As far as I've understood your question, the point is that when the investigation is not being done in the right manner, when it is being sent back to the trial court, and when the judges found that no, ठीक से नहीं किया गया, इसको दोबारा investigate करिए. So ये how to deal with those cases? Is it your question, Dr. Rajesh?
Yes, ma'am. Absolutely correct.
Okay. So obviously, in that case, I'm sure that the inquiry is going to be conducted that where we went wrong, where the police has went wrong in doing the investigations. And when usually in such cases, like in the Arushi Talwar case also, it was being observed that the way the samples were preserved and the way the entire forensic team has conducted the investigation, that was not very proper. So they would be questioned. But yes, questioning, asking for explanations, and then correcting them is one thing. It actually doubles the work. What is important is, yes, at the time when, if this is my piece of advice to obviously to all the students who are of forensic science here, that please
apart, you know better how a sample has to be collected and preserved. More than us, you know better. We don't know it. We are not from science background. But in addition to that, you should also know much in advance that how law is interplaying with the forensic science for that purposes. How, within what time that particular the sample is being sent to the concerned institution for further analysis and all that. So if forensic people know some law, and if law people know some forensics, I think we will be able to bridge the gap.
Yes, ma'am.
Very
true, ma'am. Very true, ma'am. And you have given a perfect answer. That is what I also understood. But as you are the very senior, so I should also learn from you, ma'am. So it is a very fantastic session by you. And madam, I am very much thankful to you for giving this very precious time to us, for my students, and particularly I have a very big numbers of students on this platform. And secondly, madam, we will also invite you in future also in various topic of the criminal subjects, because as you are teaching from the criminal side, so we will also invite in the where, because we are doing lots of webinars. And ma'am, I just want to tell you that we have around about 850 students, and this college has been started last 4 years back. Okay. And we have around about 200 student in 180 student in a master degree. And we have 8 specialization in master degree program, and we have around about 28 to 29 student PhD programs also. So we have different specialization, but this college is really growing very fast, as I always mention.
No, I could understand from the number you are quoting. It's really good. I mean, so many students, so many specialization is a big thing.
And this is the benefit that our president sir is very, energetic and dynamic, that he always make that every employee should do certain activities so that our institute will grow. So on this quote, I am thankful to you, ma'am, for this entire session, and on the behalf of Parul Institute of Law, Parul University, and on the behalf of all entire staff, and on the behalf of Dr. Akhil Syed, I am thankful to you, madam, for this entire session.
Thank you, Dr. Rajesh. Give me 2 minutes also to say thank you to everyone.
Yes,
thank you so much to you first, since you approached me, and so thank you so much for giving me this opportunity to study, for a little more time, to revise my little bit of forensic, because I am also learning, and still I think we'll keep on learning. So thank you so much for giving me this opportunity. It was my pleasure also, and thankful to you, to Akhil Syed sir, to give my regards to them, and to President sir, Devanshu Patel sir, and to best wishes to the Parul University, students, faculty, all stakeholders. Wish you grow better day by day and have that wisdom which is required in life. So thank you so much. Thank you.
Thanks a lot. Okay, I am thankful to Brijesh Kubani sir, who has given the fantastic live. Brijesh Kubani sir, Jiten sir, are you there? So sir, we are closing the session. So on the behalf of Parul Institute of Law, we are thankful to you, sir. Thanks a lot, sir. Okay, ma'am, we can leave now.
Thank you. Thank you. Thank you. Thank you.